Hello and welcome to Courts This Week by LiveLaw. This is Advocate Ostika Das and I'm Debojit. And over the next few minutes, we'll take you through the most important courtroom developments that took place over the last week. The cases that shaped headlines, triggered debates, and could have lasting legal consequences. So, let's begin. We start this week with a major development from the Supreme Court involving West Bengal's special intensive revision of the electoral rolls. Ostika, the court has taken a rather unusual step here, hasn't it?
It has. The Supreme Court said there's an unfortunate blame game and clear allegations and counter-allegations between the Election Commission of India and the West Bengal government. The bench described this as a trust deficit between two constitutional bodies.
And because of that breakdown in trust, judicial officers are being involved as per reports.
Exactly. The court has decided to request the Chief Justice of the Calcutta High Court to spare serving and even former judicial officers. These officers will now perform the role of electoral registration officers or EROs to adjudicate pending claims and objections under the SIR process, which is currently ongoing in the state.
Now, the state had objected to the ECI's observers, right?
Yes. Senior advocate Shyam Devan, appearing for Mamata Banerjee, argued that after the court restrained micro-observers earlier, the ECI introduced what he called a new species, special role officers, to scrutinize files cleared by EROs. And what's more is that the court has also allowed publication of the final voters list on February 28th, with supplementary lists permitted later. It has also directed the West Bengal DGP to file a personal affidavit addressing concerns about threats and violence against SIR officials.
A rare instance of the judiciary directly stepping into the election process. We'll keep tracking it. Our second story this week comes from the Supreme Court, which has issued notice on a writ petition filed by the Tamil Nadu Power Distribution Corporation Limited. Ostika, what's the core issue here?
This petition challenges Rule 23 of the Electricity Amendment Rules 2024. That rule mandates that electricity tariffs must be cost reflective. It says that the gap between the approved annual revenue requirement or ARR and the estimated annual revenue from tariffs cannot exceed 3%. And any such gap must be liquidated within 3 years for new deficits and 7 years for existing ones, along with carrying costs calculated at the base rate of late payment surcharge.
And Tamil Nadu argues this could trigger a massive tariff shock.
Exactly. According to the petition, the Tamil Nadu Electricity Regulatory Commission determined a cumulative revenue gap of around 83,000 crore rupees up to financial year 2021-2022. After restructuring the PSU responsible for generating and distributing electricity within the state, about 59,000 crore rupees of that liability falls on the distribution companies or DisComs. If late payment surcharge carrying costs are applied, the total liability could rise to roughly 70,639 crore rupees. The utility says mandatory liquidation within 7 years could lead to nearly a 50% tariff interest.
And what were the court's specific concerns?
The Chief Justice asked a question indicating concern for the financial health of states. If the state absorbs these losses of this quantum, where does the money come from? Is it not ultimately taxpayers' money? The court even asked the state to file an affidavit explaining how such expenditure would be funded. Justice Bagchi, sitting with the Chief Justice, noted that unless a concession qualifies as a subsidy under Section 65 of the Electricity Act and is provided in advance, the tariff mechanism cannot be altered. He warned that this liberal grant mid-process could create arbitrariness in fiscal administration.
And the debate on freebies resurfaced too.
Yes. The bench said while essential services cannot become profiteering exercises, subsidizing electricity even for those who can afford to pay raises fiscal concerns. The court described this as a broader issue of planned versus non-planned expenditure.
So this court pointed towards issues beyond the Tamil Nadu issue as it touches larger questions of welfare and fiscal discipline.
Exactly. The Supreme Court has issued notice and this could have nationwide implications, as you rightly pointed out.
Our third story this week brings us back to the Supreme Court in the preventive detention case of Ladakh activist Sonam Wangchuk. Ostika, can you tell us about the exchange that took place at the court?
As our viewers know, we've been tracking these developments for some weeks now. So this week, senior advocate Kapil Sibal told the Supreme Court that Wangchuk was never actually shown the 4 videos that formed the basis of his detention. According to him, only the thumbnails of the folders were shown, not the contents.
That sounds crucial to the case. Didn't the union claim otherwise?
Exactly. The union had earlier told the court that a DIG personally showed Wangchuk the detention materials, including the videos, and that the entire exercise was videographed. But Sibal said that this is the first time they're hearing about such a video of the DIG furnishing materials. He added that even the 40-minute recording shown to them had no audio, and the pen drive provided to Wangchuk allegedly did not contain the 4 videos relied upon in the detention order.
And what about the advisory board confirmation?
So Sibal argued that they were not informed that the state confirmed the detention on 4th October. He said Wangchuk received the grounds of detention on September 29th via pen drive, got a laptop only on 5th October, and later discovered the key videos weren't there despite repeated representations. He said this directly violates Wangchuk's right to make an effective representation.
And there was also the issue of translations.
Yes, that too. In the previous hearing, the bench questioned why translations of speeches ran 10 minutes when the original speech was only 3 to 4 minutes. Justice Arvind Kumar even remarked that in the AI era, translation accuracy is about 98%. The court also noted that certain allegations in the detention order didn't appear in the translated material. This week, Solicitor General Tushar Mehta said he has something substantial to say on the translation issue. Mrs. Sibal objected, saying the union had enough opportunity to respond earlier. Arguments will now continue on Monday.
We now turn to the continuing standoff between the Enforcement Directorate and the West Bengal government over the raid at the IPAC office. Ostika, the ED has filed a rejoinder before the Supreme Court. What does it say?
Yes, Devojit. In its rejoinder affidavit, the Enforcement Directorate has strongly opposed West Bengal government's claim that Chief Minister Mamata Banerjee took away materials from the search premises without objection from ED officials. The agency says that once materials were taken away during the search, it became impossible to determine whether what was removed was merely Trinamool Congress's confidential documents or material relevant to the money laundering probe.
And what about the maintainability of ED's writ petition?
The ED argues that its petition is maintainable under Article 32 because it concerns the fundamental rights of 2 categories. First, the general public, which has a right to rule of law and public order, and second, ED officers who have the right to personal liberty and to move freely while discharging their statutory duties. The rejoinder says obstruction of PMLA investigations violates Article 14 and the public's right to proper enforcement of anti-money laundering laws.
The reports also mentioned that the state had argued that this should fall under Article 131 of the Constitution since it's a center-state dispute. Can you explain that?
Yes. Article 131 was presented as the correct categorization of the rift, as the article gives the Supreme Court the power to adjudicate disputes between the Government of India and one or more states. But the ED disagrees. It says this is not about federal relations but about alleged offences and a blatant abuse of power by state functionaries. At this stage, it says the only question is whether the allegations disclose a cognizable offence warranting registration of an FIR.
And what about the claim that armed impersonators had entered the premises?
The ED has called that a camouflage. It says its officers identified themselves with proper ID and search authorization and that they were forced to wind up the raid to avoid physical confrontation. So this case continues to raise larger questions about center-state friction and investigative independence. We'll keep watching how the Supreme Court handles it.
Our fifth story this week brings us to a really important development on how courts handle sexual offence cases and an unexpected institutional response that followed. Ostika.
Yes, the Supreme Court of India has directed the National Judicial Academy to frame comprehensive draft guidelines to ensure greater sensitivity and compassion in judicial handling of sexual offence cases. This came in a suo motu matter arising from a controversial Allahabad High Court order, which had held that grabbing a minor girl's breasts, breaking the string of her pajama, and attempting to drag her beneath a culvert would not amount to attempt to rape, but rather aggravated sexual assault under the POCSO Act.
And the Supreme Court clearly wasn't happy with that approach.
Not at all. A bench led by Chief Justice Suryakant, along with Justices Joy Mallabakchi and N.V. Anjaria, observed that despite past efforts to sensitize judges, those measures have not yielded the expected results. The court has now constituted a committee headed by Justice Aniruddha Bose, along with domain experts, to draft guidelines rooted in India's social fabric, not borrowed from foreign jurisdictions. The Chief Justice even remarked that an earlier handbook on gender stereotypes felt a little Harvard-oriented. The court also asked the committee to account for linguistic diversity and even identify offensive expressions used casually in local dialects.
But this isn't where the story ends because there was a retaliation too.
Could be considered a reply, yes. Following strong criticism by a Supreme Court bench in a separate dowry death case where the order was called most shocking and disappointing, the Outh Bar Association wrote to the Chief Justice of India. They expressed concerns over repeated adverse remarks against Allahabad High Court judges, saying such comments have a demoralizing and chilling effect. Notably, Justice Pankaj Bhatia, the judge whose bail order was criticized, later even requested not to be assigned the bail roster in a separate order.
So while the Supreme Court calls for greater sensitivity in sexual offense cases, the involvement of the Bar Association indicates towards a rift between the Supreme Court and the Allahabad High Court. Our next story is one that should definitely be on your watch list. The Supreme Court has reserved judgment in a public interest litigation concerning alleged irregular allotment of public contracts in Arunachal Pradesh. Ostika, what are these allegations?
So this PIL alleges that around 1,270 crores worth contracts over the last decade were awarded to companies linked to Arunachal Pradesh Chief Minister Pema Khandu and his close relatives. This matter was heard on 17 February and after brief submissions by Advocate Prashant Bhushan, the court reserved its verdict.
And I read there were specific figures that were placed before the court too.
Yes, quite a few of them actually, as Bhushan pointed out, that 31 contracts worth 188 crores were allegedly awarded to Brand Eagles, a company owned by the Chief Minister's wife. He then referred to Frontier Associates, allegedly owned by the Chief Minister himself, which is said to have received 91 contracts worth 145 crores over 13 years. But the petition presented more details. It claims that in total, 4 firms belonging to the Chief Minister, his wife, his mother, or his brother received contracts collectively worth around 1,270 crores. According to the petitioner, that accounts for roughly 3% of the total value of all state contracts awarded during that period. The Supreme Court has now reserved judgment on whether an investigation, possibly by an SIT, is warranted.
A really important case with huge political implications, and LiveLaw will keep tracking it. Our next story deals with an important constitutional question. Will the Supreme Court lay down guidelines to curb constitutionally unbecoming speech by those holding high offices?
So a bench of Chief Justice Suryakant, Justice B.V. Nagaratna and Justice Jaymallo Bagchi was hearing a petition filed by 9 individuals seeking such guidelines. The plea arose in the backdrop of speeches by Chief Minister Himanta Biswa Sharma and a controversial video posted by BJP Assam.
But the court wasn't convinced by how the petition was framed.
Not entirely. The Chief Justice observed that the petition appeared definitely targeted against one individual since it referred only to Sharma's speeches. Senior advocate Kapil Sibal even had to clarify that no personal relief was being sought and agreed to delete references. However, the Chief Justice of India said selectively choosing individuals while ignoring others was not acceptable.
So it was outrightly dismissed.
Not exactly, because the court suggested withdrawing and refiling the petition, focusing purely on constitutional principles. It said it was waiting for a properly drafted plea on the larger issue. The Chief Justice of India also referred to Justice Nagaratna's dissent in the Kaushal Kishore case. Justice Nagaratna raised another question concerning limitations of laws regulating speech. Even if guidelines are framed, will they be followed? Before the speech comes the thought. How can we control the thought? She asked.
And there was another related development too.
Yes. Prior to this, actually, on Monday, the Supreme Court asked petitioners seeking action against Sharma for alleged hate speech to approach the Guwahati High Court instead of directly invoking Article 32. The Chief Justice of India strongly disapproved of bypassing High Court, saying wherever elections come, this court becomes a political background.
So the court rejected handling of the case completely.
For now, he said that there seems to be a calculated move to undermine High Courts and stressed that the Supreme Court must deal with its own areas. Even when senior advocate Abhishek Manu Singhvi argued that the issue involved violation of oath of office and was fit for Article 32, the bench declined. However, the bench requested the Chief Justice of the Guwahati High Court to grant an expeditious hearing. The Chief Justice of India also appealed to political parties to fight elections with mutual respect and self-restraint.
We close this week with a case that sits at the intersection of privacy and transparency. The Supreme Court has issued notice to the Union government on pleas challenging certain provisions of the Digital Personal Data Protection Act of 2023 and its 2025 rules, particularly their impact on the Right to Information Act.
That's right. A bench led by Chief Justice Suryakant was hearing 3 petitions, filed by Venkatesh Nayak, the Reporters Collective, along with journalist Nitin Sethi and the National Campaign for People's Right to Information. The challenge focuses on Section 44(3) of the Digital Personal Data Protection Act, which amends Section 81J of the RTI Act. Earlier, personal information could be disclosed if there was an overriding public interest, maintaining some semblance of balance. The amendment now provides what petitioners call a blanket exemption.
And strong arguments were made in the court already.
Yes, Advocate Brinda Grover argued that instead of using a chisel, the law has used a sledgehammer. Advocate Prashant Bhushan said that earlier jurisprudence, including the Subhash Chandra Agarwal case, had struck a balance. But the bench observed that the issue is complex and touches fundamental rights on both sides, and the Chief Justice said some ironing out the creases might be needed.
Was any temporary relief granted here?
No. The court was categorical. There will be no stay on any of these rules. The Chief Justice of India said the court will not, through an interim order, alter a regime that Parliament has enacted. Separately, the Reporters Collective has also challenged Section 36 of the DPDP Act and Rule 23 of the 2025 rules, arguing they permit unreasonable digital searches and data collection without safeguards, violating Articles 14, 19 and 21 of the Constitution.
That's all for this week's edition of Courts This Week. Remember, for a detailed report of every single story we mentioned and access to the judgments and real-time courtroom updates, visit our website livelaww.in. And if you found this helpful, don't forget to follow us on all our socials to stay updated with everything that is law.